Okay, as mentioned before, this would be my title of my talk today. This is in regards to the rise of cybersquatting and how it's a pertinent issue and that it is a threat to your trademark rights. So basically, the talk will actually explain about trademark very briefly because it's just for you for a recap and a refresh purpose. And then we will mention how cybersquatting by itself affects your trademark rights. So moving on to my first slide. Okay, so in my first slide, I will explain about trademark in a nutshell. In our past talks, you would have realized that we have actually went through all the basics of trademark. We have explained what marks are actually registrable and what marks are not. We have actually gone through a lot of aspects in regards to trademark. But just for the sake of recapping and refreshing your memory, I'll just go through what is relevant to the talk today. So first thing is, the reason why businesses actually adopt a trademark, it is actually because they want to distinguish themselves from another business. For example, if you're just going to open a business without having a name to it, you don't attach anything to it, then how are people going to refer your business? You see, a lot of businesses actually get their fame by word of mouth. And when you look at marketing strategy of word of mouth, you would need a trademark for them to actually mention, oh, you know, this person, this shop, this name. Like for example, Apple, you know clearly that is the trademark. When people refer to your phone, you can immediately say, oh, this phone is from Apple, this phone is from Samsung. So those are things, those are trademarks are meant to distinguish themselves from other competitors, other businesses of similar nature. It is usually used to actually represent the goods and services they have provided, and it's used during the operation of their business. And if we look at Malaysia itself, Malaysia actually uses a first to use system. If you wonder what is a first to use system, I will just show you. First to use means if you have created and invented a trademark and you were the first person to have used it, but nevertheless you felt that maybe probably because your business model is quite small, you felt that there is no need for you to register your trademark, then you actually basically snoozed in the registration part of it, the filing part of it, and someone else filed it. But this will not be completely fatal, because when you go to the court actually looks at the fact that who is the first person to use. If you can actually prove to the court that you were the first person to use the trademark, then the trademark belongs to you. Whereas this is very different compared to China. China, on the other hand, they follow a first to file system. If you look at first to file system, you may be stuck in a dilemma. If you do not register on time, you do not file your trademark on time, then you will actually lose your own trademark rights. So next is in regards, okay, if you look at so basically, if you look at the first to use, that as I mentioned, first to use system. So basically, unregistered trademark actually has protection because we follow the common law system, and the common law system actually accords rights and as well as protection to unregistered trademark. And if someone is using your trademark, you will be able to seek a remedy under the thought of passing off. So most of this trademark, if you want to go and file it, is usually it's under a regulatory body. A regulatory body can differ according to, because you see, when you look at trademark itself, it's territorial. So each country has their own regulatory body. For Malaysia, it's called MiniPTALK, or Malaysian Intellectual Property Office. Singapore has their own, basically every country has their own intellectual property office, and they govern the filing, the administration, the registration, renewal, and all the department is covered by this intellectual property office. So moving forward, so I would like to explain, okay, since our talk is going to be about cyber squatting, so you should know what is the difference and the similarity between the trademark, a domain name and trademark. So look at the similarity first. If you look at domain name and trademark, one of the similar thing is, as I mentioned before, trademark is meant to distinguish from other businesses. Domain name actually plays a similar role. Basically, domain name usually is adopted from the trademark itself. So it shares the similar goal that it's supposed to distinguish themselves from other businesses. It is also a very valuable asset, because nowadays, if you notice, Now with the MCO and everything, we are basically cooped up. The only thing we have access is probably our phone. We can go online and everything. So if everything, when everything is on online basis, if your domain name is stolen by another party, that can actually affect your company a lot. So it's definitely a very valuable asset to the company, and it's also very closely related to the business itself. If someone actually steals your domain name, it can affect your reputation and goodwill of your own company. But if you look at the differences, there are also differences in domain name and trademark. First thing is, trademark actually requires expertise in advising and examining. What does that mean? Because trademark actually goes through quite a stringent process. If you want to go and seek whether you can actually file the trademark, you will need to go to an expert to get their advice. Whether is the trademark still available? Is it possible for you to actually file the trademark? When you actually file the trademark to the Malaysian Intellectual Property Office or any other intellectual property office, it goes through a thorough examining where they actually examine to see whether are you encroaching into another person's right or not. And trademark, as a result, it takes a longer process for registration. It can take in between something like from 10 months to up till even 3 years or 4 years, depending on what happens in between. Sometimes you may face an office action, sometimes you may be opposed by another trademark saying that it's very similar. So usually trademark registration by itself is a longer process. Whereas if you look at domain name, all you need to go to a domain name service provider. You just go there and then you just click your name. If it's not identical, then you should be able to register within a day. It wouldn't take you so long. All you need to do is to make a payment. And on top of that, there is also a difference in the period of registration. If you look at domain name, each domain name has to be renewed. Your registration has to be renewed on a yearly basis. This is to make sure that there is no websites probably that are just going to be there, sticking there, although they are inactive. Whereas trademark, it has a longer period of protection. Usually once you have filed and registered your trademark is valid for about 10 to 15 years, depends on which country it is. Upon the filing date, you usually look at the filing date, and then for 10 years protection from the filing date, and it's renewable every 10 to 15 years. In terms of, there is also a difference in terms of the availability criteria. You see, domain name does not take into account whether it's similar or confusing name, when during the registration. When you look at trademark, if you're going to register Goggle, Goggle, or anything that is similar, they will definitely, and if you want to serve it, your nature is going to be a search engine. Definitely they will object you on the basis that it's very similar to Google. Whereas domain name does not have that kind of criteria. As long as it's not identical to another domain name, you wouldn't have any problem registering the domain. So moving forward, what is domain? So I've explained to you what is the differences and everything. So what is actually domain? Domain is basically an identification string that is in the realm of administrative autonomy, and it's just basically to have a control over within the internet. So if you look at www.facebook.com, that is a domain by itself. So the domain name is usually for a simple identification label to indicate, okay, this belongs to Facebook, this belongs to WhatsApp, this belongs to Zoom. So even this, when you entered a Zoom, this Zoom webinar, you should know that there will be a domain name that says Zoom. So Zoom is actually the domain name. An organization, when they choose a domain name, usually it will correspond with their trademark, is usually correspond with their name. They will not take something and pluck something out of the blue. They will usually take their trademark to be part of their domain name, because trademark is the main identity that the company will want to show. So having a domain name that is not relevant to your trademark will not serve any purpose. So they usually will take the trademark and put it part of the domain name itself. So if you look at, I'm just going to dissect the domain name. This is where it gets a bit technical, but it's needed. This knowledge is actually needed so that you'll be able to understand the talk better. So if you look at this, I just put an example here. So I put www.example.com.my. So what is, I just want to dissect it. I want to mention to you, what does www mean? What does example mean? .com and .my. If you look at www itself, it's actually a host. It refers to the World Wide Web. They are the host, and that's where your website is going to be sitting. If you look at .com, it's known as the generic top level domain. What is generic top level domain? All these .com, .org, .edu, all those are generic top level domain that is governed by a regulatory body, which I'll mention later. So these are a more neutral level domains which are available. And if you look at .my, they are a bit more specific. They are known as a country code top level domain. So because .my actually refers to Malaysia. If you look at Singapore, you see .sg. And then if you look at UK, they'll say .uk. And if you look at India, you'll be .in. So those are things to ensure that, if you look at a website and then when you click and then you say, oh, .sg, okay, you know that's a Singaporean page. These are actually needed, certain businesses, when they actually, if you are going to be having a business that is able to cater worldwide, then it's fine for you to stop at generic top level domain. But if your services and goods and services is more targeted, you want a targeted approach, then it's very necessary for you to have the .my at the end, because then they will know immediately, the end users will know and see that, oh, okay, this is referring to Malaysia. It's a service that's provided in Malaysia. It's a good that is provided in Malaysia. And if you look at the word example, I just putting a word like, so the example by itself, that is domain name. That is where usually people put their trademark. For example, Facebook, Apple, or Samsung, or any other name. Usually the trademark by itself will fall under the domain name. So moving forward, what is cybersquatting? Since now you should be able to grasp the idea, what is host, what is a domain name, and then what is a GTTL, which is a generic top level domain, and then what is a country code top level domain. I want to explain to you what is actually cybersquatting. Cybersquatting is actually a practice where people actually go on to register internet domain that is identical or confusingly similar in bad faith. So don't forget the word bad faith. That means people are doing that with the intention to interrupt another person's business. That is very important in whether to determine whether it's a cybersquatting or not. Cyber squatters, usually what they try to do is basically they try to leverage from your trademark rights. You may have built your business, you may have promoted your brand, you may have promoted your trademark, you may have marketed, you may have spent a lot of money to make sure that your trademark is well known among the community. So what do these cyber squatters do? They basically create a domain. They create a domain that is so similar to your trademark to confuse, and then the people when they actually Google, I mean, everybody actually basically uses the search engine and they search and they say that, oh, it must be affiliated to you. They'll assume in that way. That is what they're trying to leverage from, basically from your own trademark rights. Since the thing is, why actually they can actually do that is because the criteria is not that it has to be, it's not, if it's not identical and if it's confusingly similar also, you should be able to register your domain name. That is why cyber squatters can actually register a domain despite it being confusingly similar to your domain name or trademark. So moving forward, what are the types of domain name that are attached to the trademark? So if you look at it, first thing is cyber squatting. Cyber squatting, as I mentioned before, it is relevant to people who are the cyber squatters who actually take up your trademark and use it part of the domain name. Typo squatting. Typo squatting is interesting. What they do is basically they purposely create a typo in the domain so that there can actually be a confusion. So for example, if Facebook, if I add another O in the Facebook, you will assume that it's the same thing. It will be difficult for you to actually identify, oh, actually I'm in the wrong web page. You will assume that that is the web page that you are actually looking for. And usually most people, they are in a rush. They will usually immediately, when you're typing it in your phone, you tend to type it in a rush manner, and you will inevitably end up having a typo in your typing. So this is how they actually leverage from your minor mistake. So tweeting, on the other hand, is it's a more innocent kind of threat to your trademark. What happens is another person coincidentally actually has the same domain name as you. They do not actually intend to. There is no bad faith involved in here. And when it comes to this kind of twins, the court actually looks at the first come first serve basis, because there is no bad faith involved. So they will look at all the matters, review all the matters, and they will see whether actually uh, who is the one who came first. And in these circumstances, because the court will understand that there is no bad faith involved, they did not want to interrupt your business, but they have a genuine intention to use the domain name. Although it may affect your trademark rights, court will have to look at all other aspects as well. Parasites, on the other hand, what they do is they basically take up your domain name as part of their domain name. They do not take it immediate as a whole. They will just take a small part. For example, if you look at our company's domain name being NBS, they may add A in front. So they basically trying to leverage. They are a parasite because they adopt a element from your domain name to be part of theirs, so that you will be like, for example, maybe they are forever NBS. So they will try to insert yours. They're basically a parasite. They are trying to get the end users directed to their domain by you searching for NBS itself. So this is an example. So I'm looking at examples. So I just inserted some example in regards to celebrities. So this is Julia Roberts. If you look at Julia Roberts, she's a famous actress in the US. What happened was juliarobert.com was actually registered by another dealer, an external dealer who had no affiliation with her whatsoever. So she was not having it lah. Basically, she went and asked the dealer, you look here, this is my name. You're trying to use my name as part of the domain. And what he did was, once he knew that Julia Robert is actually interested in the domain name, he actually put it up on an auction. He put it there in the eBay and said, you can come and bid to get the domain name. So he also claimed that it's a common word. Julia, actually, to be fair, Julia Robert is not a very unique name by itself. You can see people with the name of Julia, you can see people with the name of Robert. It's not something that is so uncommon. But, so basically he's trying to claim that Julia Robert is a very common name. Why are you trying to claim, saying that, why are you trying to claim juliarobert.com? I basically, it's just a common name. Why you actually have no rights upon it? But actually, WIPO, when the matter went to a dispute resolution policy, the WIPO actually held that Julia Robert actually owned the name, because Julia Robert is a famous actress. And the fact basically the dealer actually knew his implication when he went and bought the domain name. He knew that there is an actress by the name of Julia Robert. He was basically trying to get the fame, that the actress has collected by biting the name. And then later on, when he realized the actress is trying to get back the domain name, he actually tried to leverage and try to benefit from it try to get a financial gain from it by actually putting it up for bid. So this is in an instance where a celebrity actually won the matter, but sadly it did not happen for Lady Gaga. If you look here, Lady Gaga .org was owned by a fan page. So similar to Julia Roberts, Lady Gaga was also not having it. She was not happy with this. She wanted to sue. She sued the fan page, saying that she owned the word ladygaga.org. She wants the domain name back. She actually claimed for cybersquatting, and the website was actually a fan site. It did not claim that this is Lady Gaga itself. This is my website or nothing. It's just basically a fan site where they post pictures because they adore her. They post pictures of her. They post her new songs. They release updates about her and everything. So the panel actually looked at every aspect of it. They felt that they actually did not intend to mislead or misrepresent the general public. And the panel actually found them to have acted, the respondent to have acted in good faith. actually the main reason why when I looked at this case, the main reason why they actually felt that, this is not cyber squatting is because there is no commercialization involved. There was an exception under the fair use. So that since they did not actually make any monetary gain from the website, and it was clearly created just as a fan site, the panel actually found that, there is nothing wrong. This is not cyber squatting. This is just basically a fan site, and it should be allowed. So moving on. So why am I saying I feel that there is definitely a need for a regulatory body? You see, when you look at trademark filing, it goes through, like what I said, it goes through a thorough process to make sure that, when you file a trademark, that trademark that has been filed does not encroach into another person's right. Domain name goes through a much less stringent process. All you need to do, as I said, all you need to do is to ensure that your domain name is not identical to another existing domain name. That's all you need to do. Basically, you don't go through a thorough examination or any sort. So since it's very equivalent, basically, as I mentioned, the goal and the purpose of the domain name is very equivalent to the trademark. It also overlaps in nature because basically, as I say, domain name usually will be the trademark of the company. So there is definitely a need for the body to ensure these rights are protected. It's very important during, especially in this modern era where everything is dependent on the internet, to make sure that your trademark is not only being physically used, but also in the internet. It should not be used by another party in the internet as part of their domain name. So this is where a regulatory body comes by. ICANN. ICANN is basically a multi-stakeholder group and a non-profitable organization responsible for coordinating the maintenance, procedure, or several databases related to the namespace, numerical space of the internet, ensuring a secure operation. So what they do is basically they are a regulatory body to ensure that this, they focus on this domain name system. They focus to see whether there is any infringement, whether there is any encroaching into another person's right. So they try to regulate this whole body. They work as a regulatory body. And one of the most amazing thing that they did was they came up with this thing called Uniform Domain Name Dispute Resolution Policy, UDRP. What is UDRP? You see, when matters come up to, because a lot of people, when they see their domain name being abused, they feel their trademark is being used by another domain name, they want a resolution, they want a solution fast. They may not want to go to court. Maybe the person who's encroaching their right may not be even in the same country as theirs. So this UDRP is basically a alternative dispute resolution. Rather than going to court, you come here. You come to this UDRP, and they basically resolve this kind of domain disputes. So they actually have set out procedures and requirement for each stage. If you look at the stage it's actually very well set. And you can see that, what are the required documents that you need to submit for you to show that there is definitely that someone is encroaching your right. What, as a complainant, what you need to do, as a respondent, what you need to do. Everything is well set and well laid out by the UDRP. WIPO, if you look at WIPO, which is the World Intellectual Property Organization, they are basically the dispute resolution service provider. So if you look at their goals is basically to make sure that, they try to regulate the whole intellectual property by itself. And the fact, it is a given thing that they will be the service provider, the known service provider for this kind of dispute resolution. And complaints concerning what happened is, okay, the thing is, when it comes to, if you want to go and seek, okay, you feel that your domain name is actually being, a domain name is basically, you feel there is a domain dispute and a domain name is basically encroaching your trademark right, you can make a complaint to the UDRP. But the complaint itself is only in regards to generic top level domain. That means those which comes with .com, not anything relevant to country code. If it has a country code like .my, .sg, or .in, then it does not go immediately to UDRP, whereas they look at the country itself. Some countries, what they did was they just adopted UDRP's principles. They adopted the same policies so that they follow a more regulated, uniform principle. Whereas some countries, like Malaysia, we have our own dispute resolution system, which I would say is almost similar to UDRP. So Malaysia and domain name. If you look at, okay, now moving on to Malaysia itself. So if you look at Malaysia, MyNIC is the sole administrator for all those that comes with the country code .my. It is controlled by MCMC, and one of the amazing things they did was they set up their own dispute resolution policy. This dispute resolution policy is very thorough. It's a well packaged system for you to actually go and seek, for you to proceed with a domain dispute. So MyDRP explained. So I'm going to explain about MyDRP itself. It is actually, as I said, it's very similar to UDRP. They have drawn inspiration when they actually drafted the MyDRP. They have drawn the inspiration from UDRP by themselves. That was actually set by ICANN. KLRCA, which is an arbitration center in KL, actually is a provider where the dispute resolution actually happen. And the complainant actually can choose if you want to have, if you have a domain dispute, you actually can choose whether you want to have a single or 3-member panel, and you have to adduce all the evidences that you have to say that, oh, you know what, this domain name is actually interfering with my trademark rights or interfering with my business, interrupting my business. So you need to do what? You must compile all your evidences and send to KLRCA for them to review to see whether there is actually a case at hand. And the cost is actually in between 2,500 to around 9,000. This is what I've gotten from their website itself.
So Divya, is it cheaper if you appoint a single panel member, and is it like more expensive?
Yes.
What is the difference?
The cheapest actually ranges around 2,500 to around 4,000, around there. And if you get more panels and when the complainants by themselves it involves many respondents, that means it involves many parties, then the fees will go up accordingly.
Oh, so more respondents, then you need more members in the panel.
Yes.
All right.
Yes. Okay. Because you usually require more evidences for them to review. So that's given last, so the fees will actually increase in nature.
Okay, thank you.
Okay, moving forward, I'll just move forward. So what is the benefit of MyDRP? It's actually a cost efficient. If you don't see disputes being settled at 9,000 in court. Usually court is a very costly affair. If you go to court, the civil litigation by itself is a very costly affair. So if you look at it, MyDRP and MyDRP, which is a dispute resolution policy, is actually a cost-efficient way for you to resolve a domain dispute. It is also a very fast process. If you look there, they have actually set out, okay, within this day there should be a decision. Within this day you should submit your documents, and everything is well set. And it also involves the panels by themselves are experts on the matter. So you do not need any expert evidence. You don't need to hire another person to come and explain about this. They are basically experts on the matter who are deciding on your case. So if you look at the difference, as I mentioned, there is 2 types. One is UDRP, which was set by ICANN, and MyDRP, which is sent by MCMC and MyNIC. So what is the differences? In MyDRP, the complainant is the one actually bears the burden. So if you make a complaint, you actually bear the burden to show that the domain name is identical and confusing to your trademark, that the respondent being the person you're complaining about, has no rights or legitimate interest in respect of the domain name, and the domain name is actually used by bad faith. So basically, the burden by itself lies on the complainant and not the respondent. And MyDRP, okay, the thing interesting about MyDRP is they feel that, okay, there are also people, I should mention, that that goes and registers a domain name, not to use it, but later on sell it. They feel that, okay, this name is very unique. It's now being a trend, you know, some nuances and some jargon suddenly becomes a trend and it's commonly used. So what they do, some domain, they call themselves domain investors. They go and invest on the domain. They know that at a later point of time, someone actually will come forward and say, hey, I'm going to use that. So they will, at that time, they will negotiate a price and sell that domain. That is possible under the UDRP. But when you look at MyDRP and the cases that was decided there, a mere registration itself can be deemed as a bad faith. If you don't actually intend to use and you went and register a domain, it can be deemed as a bad faith. That is the differences between UDRP and MyDRP. Okay. If you look at bad faith itself, let me explain. I've been mentioning bad faith and bad faith. So this is what bad faith means. This is what my DRP actually states as a bad faith. If you actually register to sell, rent, or transfer the domain name for profit, is actually deemed as a bad faith. If you register the domain name to prevent a trademark or service mark of an owner from using their domain name, that means basically you're trying to prevent them from using their own trademark as part of their domain name, that is bad faith. If you also register for the purpose just to disrupt the business, for example, you come up with an extra additional a few words, typo squad, you put a typo there in the mix of the domain, and just for the sake of disrupting a business, it's clear that you're basically having a bad faith. The reason why you register is under bad faith. And also when you register or use the domain name for the purpose of attracting and diverting internet users. This is basically trying to divert end users to your website instead of the main website they're looking for. So that is also a bad faith. So if you look at cases, so everybody should know what is this. This is Volkswagen, a very famous car manufacturer. You come to a surprise that actually Volkswagen.com.my was initially registered as a domain by Web Motion Design, but they actually did not intend to use in relation to their goods and services at all. They basically, the reason why they actually registered because of the fame that is involved. They feel that it's famous, Volkswagen is famous, and they saw one day that Volkswagen actually did not register the domain name, and they went forward and bought the domain name. So they were actually not even known. They've not used it. They are not even known for the domain name. They were not known as Volkswagen. It's not a coincidental thing. They have never been known as Volkswagen. And when the matter actually came to MyDRP for dispute, when to resolve the dispute, the respondent who has filed it, who basically the person who actually filed the Volkswagen.com web motion design, was held to be filed the domain under bad faith and used to leverage from the complainant's fame. They basically used the domain name to actually leverage from the complainant's fame. So in this case, it was the domain name was reverted back to Volkswagen, who is basically the rightful owner. So this is Muda.my. Around 7 to 8 years ago, Muda actually was a very famous e-commerce platform. Now we can see a lot of it, but these were one of the pioneers that was there. So if you see Muda.my versus Scalable System, the respondent being the Scalable System actually went and filed Muda to you. They actually filed Muda to you, which is, if you notice, is very close to Muda.my. So they Muda.my actually went and sent a cease and desist letter. They actually asked, they said that, you know, they were trying to sell it for a minimum of 100,000. They were trying to sell it off, and they clearly did not intend to use it. Like what I mentioned, you see, use is also important. If you don't intend to use, why are you registering another person's similar? Why are you trying to disrupt another person's business? So the panel actually deemed the respondent having been filed as under bad faith, and the Muda to you was deleted, was removed. So here, this is an interesting case. In the contrary of the two cases that I've mentioned earlier, this is in regards to Nikon. You'll be wondering why was it a contrary? Because Nikon is a very famous brand. Everyone knows that they produce one of the best cameras around. So Nikon Malaysia Sendirian Berhad First Web Enterprise versus First Web Enterprise. In this case, the panel actually decided in favor of the respondent, because actually the reason why they actually decided in favor of First Web is because it's very simple. because Nikon Malaysia were not the trademark owner. It was actually owned by Japan, Nikon Japan, Nippon Kogaku KK. That's what that was owned, the company name that was owned. And they actually basically failed to prove that the trademark was owned by them. So as a result of it, they lost the matter because they couldn't show the ownership of their trademark. If you look at the defenses that are available, if someone actually comes to you and say, this domain is mine, you should give it back to me, or, you're clearly infringing my right. So what are the defenses that are available? The defenses that are available is, first thing is, you must have a genuine intention to use the domain name. As I mentioned earlier, if coincidentally, you happen to use another person's trademark, you are using at the same time, you are coexisting all this while, and you actually bought the domain name, the panel actually looks at it on a first come, first serve basis. So because you have genuine intention, you did not have any bad faith. And also, if you can establish distinctiveness, that you actually are known by the name, domain name, then there is no bad faith involved. And for fair purpose and non-commercial use, like for example, in the circumstances where I mentioned that there was a fan site for Lady Gaga, you saw Lady Gaga actually lost the suit because it was an exception, because it was done for fair use, and there was no commercial use, no monetary gain involved in the registering of the domain name. They did not gain anything from that. So if you look at the remedies by itself, the remedies are pretty simple. The domain name will just get transferred, modified, or deleted. So that is basically the remedies that are available. Most people would just want that. So conclusion is, I would say that, it's actually an excellent effort by MCMC and RCA to adopt MyDRP, because it's very close to UDRP. Although they have, as I mentioned, there are some differences. In majority of the part of it is basically the same. And they actually adopted a very, very thorough process, a well-set process, well-drafted. So I would say there is an external effort in assisting in all this domain dispute. And also I would like to state that, domain name has to be equally protected as trademark. In this modern era, you don't want your trademark being infringed in the form of a domain name. And trademark owner should take immediate action if trademark was found to be misused in a form of domain name. You should not snooze. Domain names are equally important. People will definitely, when they look at your business, they'll definitely search your business in Google, and they will find, if they find another third party using your trademark as part of their domain name, they're going to get confused and they will assume that, that is you. So thank you. That's all for today. So Marcus?
Right. Thank you very much, Ms. Divya, for such a good sharing on an interesting topic. This is kind of new because we don't really pay much attention to our domain name, despite how we actually, spend to nurture our trademark and stuff like that. And being in the business, MBS and net business, who assist people in registering their trademark and domain name, I'm actually quite curious. How serious is this cyber squatting in Malaysia? Do we get a lot of complaints nowadays?
Yeah, I think now, yes, there are a lot of complaints in the if you look at KLRC, there are a number of cases that have been filed, but people don't actually go to court because, as I mentioned earlier, the dispute resolution that is available in Malaysia itself is pretty good. So people just go through the normal dispute resolution policy, and they actually try to get back. Yeah, the cyber squatting is there. Definitely is a pertinent issue that is existing now, even now in our cyber era.
I see. Yeah. So we know, because the question is, which business is not available online nowadays, right?
Exactly.
If your business is not available online, you have to do something about it. So trademark and domain name is definitely really closely related, and they are equally important to your business. So you have to get your domain name registered at the first instance, right? So if it gets stolen, what can you do? You can actually file complaint and get a dispute resolution. Of course, the process will be tedious, and it involves additional costs to actually prove that it's yours and it has been registered by others in bad faith. Am I right? So you have to get your domain name registered quickly when you start your business. Yeah. So with regards to this, how because we know that trademark registration is a very tedious examination, and Divya, you said that domain name registration is quite easy, right? So how do you actually get them registered? Like, you know,
You're asking me how do you get domain name registered?
yeah,
Actually,
yeah.
it's a pretty simple process. You just go to a service provider. There are many actually what they do is you basically put in your domain name. They will check whether it's available or not. If it's available, then basically they will just allow you to actually register the domain name. And you will be surprised in certain instances. I'm just sharing that sometimes the domain name looks almost identical, because what they do is basically change the homophone. If you're not concentrating and looking at it very clearly, you will notice there is no difference to it at all, but it's available for you to actually register as a domain name just because the homophone is a bit different. So I would say that, when it comes to, as I said, domain name is extremely easy to register. They don't go through a stringent process like trademark. So it's extremely important to make sure that your trademark is not being infringed in the name of domain. So that's very important.
So meaning people can actually go directly to MiniPTALK or find agents who does this.
Yes.
Yeah.
Yes, correct.
Right. Okay. So any questions from the floor? You can type it on Q&A in our Q&A section or in the Facebook. Let me check. Oh, we have a question. Can I register my domain name under trademark?
You should be able to register, but certain like .com, .my, and the .ww is all generic. You will get it disclaimed anyway. So it's best for you to actually just get your domain name. I mean, as in, like, if you're going to go for the full name, then you cannot. But this the domain name by itself. If you're not, it's not part of any other trademark. It's not being used by any other prior mark. You should be able to register it.
So meaning you cannot register abcd.com as your trademark, but you can register ABCD. Does it mean that?
No, you can register abcd.com. It's just that .com by itself will get disclaimed later on. So you can just register ABC by itself. But if you want to protect it as a whole, yeah, you may proceed, but you just get disclaimed.
So it's like the case of booking.com, something like that?
Yeah. Booking.com is very popular. If you look at their website, their trademark by itself, it has the word .com. But what they will do, because .com is not something that you can claim, it's something that is very generic. So .com will inevitably get disclaimed in the trademark process.
All right, I see. So any other question from the audience? Give me a moment, let me check the Facebook. Okay, so no more question. All right, so we've come to the end of our talk for today. So thank you very much to the audience for attending to this morning's talk in Malaysia, and people who are watching worldwide. Thank you for spending your time, and thanks to our panelists, Ms. Divya, for sharing with us your very interesting knowledge and thoughts. Yeah.
Okay, so, thank you, Marcus. Thank you so much. Thank you for giving me the opportunity as well.
Thank you. So for those of you out there, you can check out our Facebook page, NBS Facebook, www.facebook.com/NBSMY for our coming talks and events, or check out our official website, www.nbs.com.my. Right, so if you need assistance in registering your trademark, you can approach us. Not excluding, we also provide service for domain name registration under our branch, netbusiness.com.my. All right, thank you very much.
Thank you.
Bye-bye.
Bye-bye.